All right, appearances for the township. Have a seat, make yourself comfortable. All right, so Mr. Crucell, you filed a number of motions. I'm going to let you pick which one you want to deal with first.
Well, this emergency motion stay needs to be addressed immediately, requesting the judicial bias and the process violation.
Okay, just hold off with the argument. Hold off with the argument. The question was, what do you want to start with? Okay, so you filed something Friday. I took a quick look at it today. Is that any different than the motion to stay that you filed previously?
This is just bringing the fact that all the motions I have filed.
Is that a yes or no, Mr. Crucell?
But it's covering all the judicial bias.
Okay, listen to my question. Is it any different than the last motion to stay proceedings you filed? Okay, just give me what you've added since the last one, because this one I haven't had a chance to read fully. The first one I read fully.
I just have the same issue to me telling you didn't give a shit about what I had to say.
Okay, hold on. Mr. Crucell, this is going to be a very long day for you if you don't listen to my questions and answer my questions. That was in the original motion to stay proceedings. I've asked you to give me whatever's new in this motion.
New stuff covers just Gene Green telling me to sue the Secretary of State rather than addressing the due process violations in my case.
Okay, stop right there. How does that lead to why this should be stopped today?
All of this is stemming from where all of this should have been stopped a while ago.
That's not the way it works. Mr. Crucell, hold on. Okay, that's the last time you're going to interrupt me today without a contempt of court charge. Is that clear?
Your Honor.
Is that clear?
She gets me this entire time. No one has made her answer.
One more word, and it's contempt of court. It's $100 a contempt, and if I get totally fed up with it, then I'm putting you in jail. Okay? Just because she and I happen to agree on the law as it applies to your case doesn't mean we're in collusion. It's possible that you're wrong. At least accept the possibility that she and I have the same opinion about something. That doesn't mean we're colluding. You understand that concept? Do you understand that concept?
You're supposed to be impartial.
I am impartial. I've been trying to save you. Just because I agree with the prosecutor doesn't mean I'm against you. It just means I agree with the prosecutor.
So it means if you're agreeing with that, definitely means that you guys are lying against us.
So that means in any case, when I buy the arguments from one side, that means I'm colluding against the other.
You're agreeing.
Yes or no, Mr. Crucell? No, you have to answer my question. Contempt number one, $100. Answer my question. Every time I rule in favor of one side, does that mean I'm colluding against the other? Yes or no? $200. Yes or no? Because I can do this all damn day. And when I get tired of this game, then I tell them to put you in custody because it's contempt.
Welcome back to the channel, everyone. Today's case dives deep into one of the most chaotic and tension-filled hearings we've seen in a while. On one side, a self-proclaimed sovereign citizen, Mr. Crucell, who insists the court has no jurisdiction over him. On the other, Judge Oakley, known for his sharp wit and zero-tolerance approach to courtroom theatrics. What starts as a simple procedural hearing quickly spirals into a full-blown standoff over authority, law, and order. And now, if you've ever wondered what happens when someone challenges a judge in real time, this is it. You'll see the judge's patience tested, the defendant's logic stretched, and the courtroom teetering between chaos and control. But here's the kicker: despite all the shouting about rights and jurisdiction, the legal system remains remarkably consistent. So as we go through this, pay attention to how the judge maintains composure and control, because it's a masterclass in judicial restraint.
Judges, by definition, have to decide in favor of one party or the other. That's what we do.
When you made that statement, you were making.
What statement is that? I thought we were talking about Judge Green's SOS statement.
When you made the statement that you were setting aside my regular trial, saying that you're saying that the prosecutor, the township, and his court all see things the same way, setting that aside, not even allowing me to make my argument. So you were aligning yourself with the prosecution on the argument of my point and setting it aside, and what you were doing.
Mr. Crucell, what I was doing was aligning myself with the law as I see it and interpret it. Stop. You can't just shake your head. You don't just disagree with me and move on. If you don't like a ruling from a judge, you have to appeal that ruling. You don't keep arguing with the ruling. That's not the way the process works. Listen, brother, listen. I have tried to save you from yourself. If you remember the first time you were in my courtroom, I tried to get you to see things the way the process was going to move forward. Because, dude, this process is going forward the way I want it to move forward. You might not like that, but I'm in charge of the courtroom. And at the end of the day, if you don't like anything I do, you can appeal me. That's why they have circuit courts. But I'm not going to let you make this a dog and pony show, especially when we've got jurors here.
Dog and pony show. This court has failed to let me make any of my statements, any of my cases. You even were trying to threaten me with contempt. Anytime I tried to.
I am threatening you with contempt.
My objections on the record, you make my case. So you're
No, because third contempt. Do not interrupt me. When I said your objections don't mean shit to me is because you were using the word objection inappropriately. You objected every time I disagreed with you. If you have an objection, you have to have a legal basis for the objection. For example, she's trying to put a video into evidence. And you say, I object, Judge. She hasn't laid a proper foundation because all she said is, Judge, I've got a video. I'd like to play it for the jury. That's a proper legal objection. When I rule in her favor and you say I object and I say, what's your objection? And you just disagree with me, that's not a legal objection. That's why I said your objections mean shit to me because you're not using the word appropriately. Because you don't know what you're doing. That's what I tried to tell you originally the first time you were here. You've never been to law school. You've never tried a case. You don't know the rules of evidence and all the other things that have to be in play to have a trial go forward appropriately and properly.
The first contempt warning of the day. The judge has already made it clear, this isn't going to be a free-for-all debate. Notice how quickly the tone shifts from procedural to disciplinary. What's happening here is classic courtroom mismanagement from a pro se litigant, someone representing themselves without fully understanding the rules. The judge gives multiple chances for clarity, but each interruption digs the hole deeper. And when the defendant accuses the judge of bias? That's the nuclear button. Judges must control proceedings. Any hint of insubordination threatens the court's authority. This is where patience meets the
Okay. All right. So let's do it this way. What motion would you like to address first? The motion to postpone? Denied. I'm not denying the jury trial.
Especially with the jurisdiction, she's never once permitted on the why is on the prosecutor to prove those things. There's all sorts of irregularities.
All right, let me stop you for a minute. What do you mean you're not going to proceed? You're here.
Everything is taking place now shows exactly that there is enough to show. You need to
Once again, you're not answering the question I asked. You just said you will not participate, and I asked, what do you mean by that? I'm not asking you to explain your reasoning. I want to know, what does that mean? I'm not going to proceed with this. You're here. So when I impanel the jury, what? You're just going to sit there and not going to talk? What does it mean when you say you're not going to participate?
And go through until these things get addressed. All of my issues that have been ignored this entire time, especially excluding people.
Once again, if you accept the motion and I deny it, it's been addressed. You might not like the way it's been addressed, but then you have to appeal it.
That's the whole point of me getting all my objections.
All right, what's your objection? What's your objection to me denying your motion to postpone this trial at the last minute?
I'd like to put on the record that if whatever you would like to do from there, you can, because I won't until these things. Like I said,
Hold on. Is this statement preceding all these motions you filed? Okay, then let me make my ruling on all of them.
This exchange perfectly captures the clash between legal reasoning and personal conviction. The judge is explaining a fundamental principle that agreeing with the prosecution isn't bias, it's judgment. But for Mr. Cazell, any agreement feels like betrayal. What's fascinating is how the judge uses logic to dismantle the argument while still offering a path forward. If you disagree, appeal it. That's the due process at work. It's not about who yells louder, it's about who follows the law. And if you listen closely, this is the judge's attempt to pull the hearing back from total.
I think there's a motion to dismiss for lack of jurisdiction, correct? Okay. Would you like to respond to that one? Because I think that's already been addressed.
Speaker, please arrested Mr. Crusoe while he was in Huron Township. 34 District Court has jurisdiction over offenses that occur within the township, both civil and criminal cases.
Did you appeal Judge Green's decision on that motion?
I'm investigating because I've been in contact with the appeals.
Okay, so there's no appeal filed yet, correct?
Getting all involved.
I'll take that as a yes. There's no appeal filed. That motion is denied then. She made the ruling. You don't get to ask me to make the same ruling. Once again, don't interrupt me because I can go to 4 real quick. Judge Green, a judge in this court, ruled on that exact motion and denied your motion. That motion has not yet been appealed, and it certainly doesn't get appealed to me. Is that clear?
Yes.
Thank you. Next motion. Motion to
The judge can't just come in here and say that.
Delivers a rare moment of legal education mid-chaos. He breaks down how objections actually work, a move both practical and generous considering the tension. This isn't just scolding, it's teaching. The sovereign citizen movement often thrives on pseudo-legal jargon, but when faced with real courtroom structure, their arguments collapse under procedure. The judge's "your objections don't mean anything to me" line sounds harsh, but it's technically true when there's no valid legal basis. This VO moment highlights the vast gap between internet law and actual
court. A judge made a ruling. You don't get to keep arguing that same motion.
All she said was that Judge Martin was setting aside and that I should go sue the Secretary of State. The things that she's claiming and saying were never said to me. And I have all the recordings and they were submitted to the court. These things were never said to me. And then she comes here and makes these accusations and saying that the judge said this, the judge said that.
Fine, then I'll say the same. I'll say the same thing to you. Listen to me. Here, on your motion to dismiss for lack of jurisdiction, denied. By me, you can appeal me. Because the reason she stated, the Township of Huron issued you a citation. This court has jurisdiction over citations issued by the Township of Huron. So for that reason, I'm prepared to move forward and adjudicate that citation. Is that clear enough so you can appeal my decision?
Fine.
Okay. Next one up is motion to reconsider for bias and judicial misconduct. Denied. Would you like me to clarify that in any way?
Yes, absolutely.
Okay.
Okay.
Then guess what? The Court of Appeals can overturn me because I'm not biased to you. You might not like the way I talk to you. You might not like the things I say to you, but I'm not biased against you. Believe it or not, brother, I would like to save you from what's going to happen today. I really would. Because here's my dude, let me talk. You have turned what should be a fairly minor misdemeanor and civil infraction situation into a huge mess. I don't think it's going to end well for you. I tried to save you from that the first day you were here when I tried to convince you to have some conversation with a court-appointed attorney, and you didn't want to do all that. I know in my heart of hearts, I have no ill feeling towards you whatsoever. And I'm going to give you the best trial I can give you today if you decide to participate. But I am not going to let you drag things in front of this jury that I determine are not relevant because that's my job as the gatekeeper after the judge over the trial. I'm not going to let you get into a bunch of arguments that I think are just going to cloud issues if I don't think they're relevant. That's my job as the judge, not because I don't like Mr. Crucell. It's because my job as a judge is to run this trial efficiently and effectively. And I'm going to do that. And if I do that, I anticipate I'm going to step all over your toes and your beliefs. But that doesn't mean I don't like you or I have bias against you. So I am denying your motion to recuse myself. Anything else you want to put on the record so you can appeal that decision? Once again, stop. That's an improper use of an objection. What you want to say is, I disagree with that, which is fine. That's why you appeal it to the circuit court. But it's not an objection. What's your legal objection to my ruling? That's not a legal objection to a ruling. That's not a legal objection. So that's 2 motions down. The next one is motion for relief from judgment. I'm assuming that's Judge Martin's decision to set aside your defaults. All right. Do you really want me to grant that motion? Because if I grant your motion, that means the default that was set aside, defaults that were set aside are reinstated. Is that really what you want today?
Well, listen, the thing is,
Mr. Purcell, yes or no? You filed a motion asking me to set aside a decision that was made Do you really want me to set that decision aside? Because that means those civil infractions are then in default and they're done. Is that
The judge brings everything back to jurisdiction, the cornerstone of sovereign citizen ideology. When Mr. Cazell argues the court has no authority, the judge calmly lays out the legal foundation. The incident happened in Huron Township, therefore, the 34th District Court has jurisdiction. It's not subjective, it's statutory. The defendant's refusal to accept that principle is what turns a minor case into an escalating conflict. You can feel the judge's tone shift here, firm, final, and procedural. It's a reminder that courtroom law isn't
to reinstate those default judgments? Then I'll deny that motion. All right, you filed something called Notice of Constitutional Rights, which I didn't see anything where it required me to make any decisions or anything else. You're just letting me know that you're standing on the Constitution? So am I, all right? The emergency stay we dealt with. You also file an affidavit of non-consent. You didn't need to file paperwork for me to know you didn't consent with the proceedings, but I got the message there. Was that the only message I was supposed to get out of that document?
Essentially, yeah.
Okay.
Prosecutors.
Okay. I don't need a preachy moment. I just want to make sure I wasn't supposed to get anything else out of that affidavit other than you don't like the process that we're involved in. Next thing I had on my list was affidavit of non-consent. Motion for judicial notice. What does that judicial notice of what?
Certain terms that everything that this prosecutor keeps trying to use and apply in this case that are not the lawful terminology being used. Okay.
For example.
You use motor vehicle.
Okay. Motor vehicle's pretty much a term of art in our business.
Law differences between how it's being used. Absolutely.
Well, then you can make those arguments. But you can't tell her she can't use that phrase. Yeah, but I'm not the trier of fact. So if you want to make an argument to the jury that her use of the term motor vehicle is improper, you can make that argument.
The emotional fatigue in the courtroom is palpable. The judge actually tries to appeal to reason, almost as if he's coaching Mr. Cazell through the legal maze. He acknowledges the defendant's frustration but emphasizes something key: being biased and being decisive are not the same. The judge is doing everything by the book, yet he knows how this is going to end: another inevitable appeal or contempt charge. What's striking here is his humanity. Beneath the firmness, there's a real effort to save the defendant.
Is that what you're concerned about? Is you're not going to be able to make the argument?
Yes.
Get what stuff on the record?
Filings.
Well, I can guarantee you're not getting all these filings on the record because the jury has no reason to know about all your motions.
All of this has to go. Everything is taking place.
No.
Exactly.
No, that's not the way it works.
It's where the sovereign citizen logic fully unravels. Mr. Cazell insists he can dictate courtroom procedure, that he can decide what the jury hears, what evidence gets admitted, and even what terminology is allowed. But the judge's response is textbook judicial authority. That's not how any of this works. The repetition is deliberate to reinforce control while educating the audience. It's the perfect storm of delusion meeting discipline. If you've ever doubted the importance of judicial gatekeeping, this exchange proves exactly why. It's where today's hearing leaves us: a defendant entrenched in his beliefs and a judge unwavering in his duty. Despite the shouting matches, the contempt fines, and the repeated legal misunderstandings, the system held firm. This case is a fascinating study in courtroom psychology.